I welcome all the participants to this wonderful webinar on personal data protection laws in India. So I request our President, Mr. Sharat Kumar, to inaugurate by speaking a few words, and then we will start it. Sir, Mr.
Thank you, KRK. Welcome my colleagues from the ACFE fraternity, and we very heartily, with a applause, welcome Sri Naavi Vijay Shankar, who is a very known authority in the data protection. I will not take much time because Radha cautioned me few words he said specifically, emphatically. Okay. The few words I want to say, we all earn hard to make some money and we protect them either locking in the locker or in the bank locker or in the bank passbook and all that. Data is the current day wealth. In the current scenario, present scenario, data is the wealth. We are least bothered how to protect our data. We leave our data helter-skelter, which is giving rise to so many problems like theft of the data, misuse of the data. Like in fraud examiner community, we are entrusted with the very, very valuable and sensitive data. If you don't know how to protect that and some hacking occurs in the data you are handling, it's a shameful thing on our part to admit that we allowed it to happen. Sri Vijay Shankar is an authority. We senior to all of us in the years and pioneer in the activity of data protection laws in the India. He is just sharing with me. He went ahead and started training, online training in 99, as far back as in 99. He's a pioneer and visionary, and we should immediately, immensely benefit by his session today. Please feel free to ask any questions, and I really thank Radhakrishna Rao for taking the initiative of requesting him and for him, Sri Naavi, to have readily accepted to address our gathering today. Thank you very much, sir. Thank you. Wish all of you a great session.
Sir, before Naavi starts his session, just I want to add a few words for the benefit of our participants who may not be knowing much about Naavi, sir. Mr. Naavi is Mr. Vijay Shankar. He is popular known as Naavi. He is from Bangalore. He is pioneer in India in the fields of cyber laws and data protection laws. I think most of you may be knowing Naavi.org, NAVI.org. It is his pioneering website, started I think 98 or 99. You can see the updates, regularly he updates the website. Some more websites worth visiting is Cyberlaw College. He has a cyberlawcollege.com and privacy.ind.in. That caters to the privacy laws, privacy information. And very important, I think we don't have any such facilities in India like CEAC.in. Just now he was discussing. Cyber Evidence Archival Center. You see, if it is a documentary evidence, we can protect it on our own. But if it is a cyber evidence, it's very difficult to protect. In such situations, he comes to our rescue and he protects and preserves that evidence in the way that is acceptable to the court. That's CEAC.in. Please visit and you can see. And Mr. Naavi is a regular visiting faculty to many colleges, especially the Nalsar in Hyderabad, BMS Law College in Bangalore, National Police Academy. And most important thing, as far as this data protection laws is concerned, he founded an organization called Foundation of Data Protection Professionals in India, FDPPI. And he is conducting courses on that. He is the founder chairman. He is conducting courses. He is also giving professional certificates. No other organization in India is giving the professional certificates. You can make use of them. And it's a great opportunity for us to listen to him. We are fortunate to have him with us. I never forget that when I requested him to take a session for us, he readily accepted without thinking even for a moment. So we should be grateful to him. And okay, these are the most important things. If I explain about him, I have to take so much time. So now I request Naavi sir to start his session. Thank you.
Thank you. I will be first sharing my screen. Are you able to see my screen now?
Yes, sir. Yes, sir. It's visible.
It's visible. Okay. Fine. If there is any problem when we are viewing the screen, you please tell me. Okay.
Sure, sir. Okay.
Okay. So as Mr. Radhakrishnan was suggesting, it is also my pleasure to have been able to address this August gathering. I hope I will be able to communicate certain aspects of this emerging data protection legislation in India, which is presently coming into the system. As you know, we need to understand this new law. So what I have done is to set an agenda, basically with the objective of being aware of the law, to be ready with when the law becomes, you can say, operative, and if we are associated with any organization, try to be compliant from the 0 day. And in the process, as I have been telling in FDPPI, we should be as much self-reliant as possible. That is the idea of our certification program, Certified Data Protection Professional in India. And we are also working on an indigenously developed information security framework focused only on PDPA compliance. No such framework is otherwise available. We are working on that. And as fraud examiners, you know that we have to be eternally vigilant because it's a dynamic situation. The law is evolving, and the Indian law will get to some extent influenced by the global developments. So this learning process of what is personal data protection regulation in India does not stop with studying what is the bill and when it becomes an act. It is a continuing requirement which we have to be careful to follow. Now, this Personal Data Protection Act, which I am referring to as PDPA, has not yet become an act. It is currently a bill. It is called Personal Data Protection Bill 2019. It is in the Parliament. It is with the Joint Parliamentary Committee. Committee is having multiple discussions already on this topic, and hopefully in the next parliamentary session, the final version of the bill will be presented and perhaps passed. This itself is actually a second version. Immediately after Justice Sri Krishna concluded his global study on the data protection regulations world over and presented a version called PDPA 2018 as the bill version. That was also presented in the parliament, but it did not get passed because the parliament changed subsequently. And the new version 2019 was developed. So we are now in more or less the second generation regulation in terms of discussion. And we hope that with some minimal changes, it will continue to be accepted later on as the act. Okay. Now, one thing which we have to observe is that this Personal Data Protection Act, PDPA 2020, that is the name which will be given to this act if it is passed within this year. Okay. This is actually a transformation of our existing regulation on data protection, which is already available in Section 43A of ITA 2000, amended by an amendment bill which was passed in 2008, but it became effective from 27th October 2009. So from 27th October 2009, data protection legislation was available in India in the form of Section 43 capital A of Information Technology Act. Now, what is happening is this particular section is being replaced with a full act, and that is what we call as PDPA 2020. Now, why I make a mention of this is that PDPA 2020 need not be considered as a new law which will come into effect only when it is notified, etc. It is a seamless extension of the existing information technology Act with certain modifications. For example, 43A is applicable to body corporates, whereas PDPA will be applicable to every kind of organization, which may include, let us say, NGOs, which may include associations like yours. So there is no restriction as far as the applicability of this particular act is concerned. It will be applicable for individuals also, provided they are doing data processing for commercial purposes. There is an exemption, of course, for people who will be called small entities doing only manual processing. Okay, small entities doing manual processing are exempted, but that will be a very small category today because of the GST in India. There is no small entity also without being, say, involved in computerized processing. So I personally feel that the Data Protection Act, as it is envisaged now, will be perhaps applicable to more or less everybody in India. And we have to wait and see how the Data Protection Act grants some exemptions. I am expecting that some exemptions would be granted to NGOs and other smaller organizations, because the Personal Data Protection Act of India has very cleverly made it flexible to give the Data Protection Authority certain, I can say, ability to define where the exemptions could be given. For example, the exemptions for small entities can be given not only on the basis of turnover, which is a very common factor which is used, but on the purposes for which the data is being processed. So if the DPA feels that an association like ACFE requires to be given an exemption, DPA has got that power. So that is one of the things we have to remember. Otherwise, what was applicable today only to body corporates will now be applicable to various other kinds of organizations. Now, 43 capital A actually talked about sensitive personal information, and now the PDPA talks about even non-sensitive personal information. Okay, so to that extent, again, the applicability has been extended under the PDPA. Then the Information Technology Act suggested that there should be something called reasonable security practices which body corporates handling personal information, sensitive personal information, should follow. Now, meaning has been given to this reasonable security practice by this entire act. This entire act talks about what is the meaning of reasonable security practice. So that what was a simple thing in Information Technology Act has now become a full-fledged act in itself. So this is another important thing which we have to remember. Now, under Information Technology Act, many of you are aware that there is a concept called due diligence. That is, if you are not expressing due diligence, the organizations will be vicariously liable for offenses committed by their employees or somebody else who uses your infrastructure. Okay, that is how in the case of, say, Bozzy.com, the CEO of Bozzy.com was actually charged with the offense of Section 67, which was actually committed by one IIT Kharagpur student way back in 2004. So corporates are always worried about the offenses which may be committed with the use of their resources for which they become liable. So the Act has been speaking about the concept of due diligence and given something of what we sometimes refer to as safe harbor, saying that a company will not be liable if they are following due diligence. So that due diligence concept in ITA 2000 is present, and what does this due diligence concept say? Due diligence concept doesn't say there will be a checklist which you have to follow 1, 2, 3. Due diligence is like a moving target which the managements have to understand based on the environment. And if there is a fraud somewhere in USA, I am sitting in India, I should perhaps put in security measures to ensure that such a fraud does not happen in India. That is due diligence. That's why we say under due diligence, an organization need to monitor the entire ecosystem and try to learn from that. So that is due diligence. Now, if you look at that as a concept, if the government of India is trying to replace section 43 capital A with something called Personal Data Protection Act and has already formulated a bill which has been presented in the parliament, which is in the advanced stage of getting passed, I say that this personal data protection bill in its current stage becomes a due diligence guideline to the organizations to be followed as part of the reasonable security practice of Information Technology Act section 43 capital A. So therefore, I say that don't wait for PDPA to be notified. Please look at that as a corporate responsibility and implement it right from today. The other difference which we can look at from the ITA 2000, which is a cyber crime law, and this PDPA, which is a compliance-oriented law, is that the penalties under Information Technology Act can be implemented or invoked only when there is a loss which has happened to a victim. Whereas under the PDPA, which is a compliance-oriented law, the law says that you have to take this kind of a due diligence efforts in order to prevent a data breach, in order to protect the privacy of somebody. That is the objective of the Act. And for not taking such measures proactively, penalties can be imposed under PDPA. Therefore, the companies who are complacent under Information Technology Act to say that, okay, let something happen, let somebody go to the police and file a complaint, then we will think about what to do. Today, they cannot do that because there will be a regulator and the regulator will be watching what companies are doing, and even if there is no data breach, the regulator may perhaps impose certain penalties on the organizations. That is one of the differences which PDPA brings in. Now, when we look at this PDPA from ACFE kind of a consideration, we must understand that any law will be actually having different perspectives. Okay, you might have heard in the newspapers, media, that this law is good, this law is bad, it gives government too much of powers. All these criticisms are there. That is something which should not derail the basic objective of this legislation. So that's why we need to look at the particular perspective from which people are commenting on PDPA. There is a set of people whom we can recognize as privacy activists. Their viewpoint is privacy is paramount, even against national interest. So even if the country is going to dox, they say privacy should be protected. That is the one extreme viewpoint of privacy activists. That's why there is a specific section in PDPA called section 35, which says that in the event of a requirement arising out of national security, sovereignty of India, or something of that nature, which is all exceptions available under Article 19(2) of Indian Constitution for all the fundamental rights. Okay, and section 35 says, in such conditions, the government has the power to exempt any agency of the India from certain provisions of information with the Personal Data Protection Act. That is, this exemption is given conditional to the fact that there is an exception situation as given in Article 19(2), and it is given only to designated agencies and through certain due process, and the Act says that there is an exemption. But somehow the privacy activists sometimes don't understand these limitations and say government is going to usurp the privacy across the country and there will be a surveillance state. There are so many things which people are calling. They say Orwellian state will be introduced in the country and so on. All that arises because a privacy activist sometimes looks at things in a myopic manner, not looking at the security requirements. We as citizens of the country are concerned about our security, and all fundamental rights are also to be considered as part of protection of the security. Nobody has defined security as a fundamental right, but security is a fundamental right, because without security, if I don't exist, I am not worried about privacy as another right which I want my constitution to guarantee. So this is something which you must keep remembering. Between now and the JPC passing the Act, there will be a lot of media reports, many eminent persons criticizing the Act, but look at it from the objective. Similarly, if you look at this PDPA from the perspective of an information security person, CISO or CTO, his perspective will be slightly different. He will be saying that I have been managing the information security of this company for ages. I am an expert. Now suddenly this Act comes and says there will be a data protection officer. Why can't I be the data protection officer? I am already protecting the data on the whole. Now when it comes to personal data protection, there is a law which provides some kind of a significance to somebody else called DPO, and it says DPO should report directly to the board. It doesn't actually say, but it is what we presume. So the CISOs and CTOs are feeling that the law is unfairly pitching some legal person to come and occupy an important position. So this may be their perspective. Then there is the CEOs and the boards, which will be worried because the penalties which this particular act will impose is unheard of in our Indian scenario. So they are worried how to ensure that my company, with whatever objectives I have, does not perhaps violate the provisions of this act. This is particularly true of organizations which will be in direct marketing activities where personal data is sometimes becomes a commodity. In fact, as Sharath was mentioning, we often use the word data is an asset. It is like oil. And the idea is that that value has to be harnessed by an organization. Now, when harnessing that organization, this Personal Data Protection Act wants us to make a distinction of the personal data protection, because protecting the personal data is essential for protecting the privacy of an individual, because the Supreme Court in its Puttaswamy judgment has held that privacy is a fundamental right of an Indian citizen. And protection of that privacy is possible only by protecting the data connected with the identifiable individual, which is what we call as personal data. So this is how the company will be looking at. And in fact, some of you may be aware that the government of India is also trying to bring yet another legislation for management and governance of non-personal data. Personal data by way of protection is being handled by PDPA. To some extent, non-personal data, to the extent it becomes a subject of a crime, is being handled and will be handled by Information Technology Act. Beyond this, cyber crimes associated with non-personal data, then everything connected with personal data being addressed by ITA 2000 and PDPA, the government feels that if we want to harness the value of data as a national resource, we need to look at governance of non-personal data, for which one Gopalakrishnan committee had been formed. It had given its recommendations about a week back. It is now available for public comments up to August 13. When that rolls out over a period of time, it may take another 2-3 years, we will be having another act called Non-Personal Data Governance Act. That will be related to governance, but today we are talking of Personal Data Protection Act. Now, as a fraud examiner, okay, you must be more focused on what is the viewpoint or the perspective of a fraudster when it comes to PDPA. He recognizes that PDPA or the personal data has become a more valuable asset on account of this law. There are fear of fines in the organization, and this Personal Data Protection Act, like GDPR or any other law, may also provide an opportunity to the fraudster to hide. So a fraudster will be looking at PDPA happily because the value of the personal data which he can steal has gone up, and the organizations are very much afraid. So if you can threaten them and have extortion, you are likely to get your money, and there is always an opportunity to hide. For example, if you look at the recent instance of the Maze ransomware, which attacked one of the prominent companies in India, Cognizant, it is supposed to have resulted in a loss of 50 to 70 million US dollars. We are talking of 5 to 7 crore dollars. So we are talking of 50 crores of Indian rupees. Why this happened? Because this ransomware entered the system of Cognizant and it actually encrypted certain data, made it unavailable for the day-to-day operation. So there was a denial of access. Business could not go on. Then these people said to Cognizant, you please pay me some money in bitcoins, not even in legit currency, in illegal form of currency. And they have extracted some money. Nobody like us know exactly what is the amount. We are estimating that it will be around 50 million. That is not to be taken as confirmed loss of, let us say, Cognizant. Okay. But this particular Maze got more credibility in terms of extortion capability because this not only encrypted the data, but also threatened that they have already exfiltrated the data in unencrypted form and it is being held with these extortionists and would be released to the dark web if this ransom is not paid. So it was a combination of denial of access and a threat to make what may be considered as a sensitive personal data and non-personal data public. So under this fear, the company was forced to perhaps accept the ransom, and having accepted the ransom, they would have gone to the dark market to buy bitcoins, which itself is an illegal activity, and they have made the payment. Perhaps, okay, let us look at it as within these four walls of this system, that is the market information. Why did the organization make the payment? Because they felt that if there is an exfiltration of personal data, then there may be administrative fines coming from GDPR. Indian PDPA is still not in place. GDPR is already in place, and there may be fines, and the fines of the GDPR could be not 50, 60 million as these extortionists are claiming. It may be 100 million, 300 million, 500 million. So the fear that there will be a greater administrative loss, the companies are prepared to shell out something to this extortionist and take the risk that they are dealing with a fraudster who may not keep his word, or he may keep his word for 6 months, and after 6 months again come back and say, money is not sufficient, you give me something more. So this kind of a situation is created by this ransomware because there is a legislation called GDPR which tries to regulate the personal data on a global scale, and there is an administrative fine attached to it. Similar thing will come in India if PDPA had been operative. Fortunately, it is not yet operative in India. So today, if anybody wanted to claim any compensation on account of this kind of a ransomware, they have to bring it under Information Technology Act, prove that something wrong has happened to them, wrongful loss has to be proved, then only they will be able to claim any compensation, which is little more difficult. Then comes the evidence, then comes the forensics to prove that the loss has been occurred to a particular person and it has occurred due to a negligence of a particular company, etc. So since that is quite difficult, the probability of a company suffering a loss under Information Technology Act on account of the ransomware is much less than in the case of this data protection regulations, where without waiting for finding out what is the law, there will be immediately a fine. Now, from the fraud perspective, we should also look at this PDPA as something which brings about a total change in the operations of an organization. It disrupts the entire operations. When you disrupt the entire operation, two things can happen. One, the existing systems which are working well will get disturbed, and that disturbance may cause new frauds or opportunities for new frauds. There is also, of course, a possibility that sometimes when we try to revamp our systems, we may unearth certain hidden frauds. We have, as fraud people, you must have come across such things. I had come across one such situation way back in a Salem hospital, where when they changed their system of database, suddenly they realized that in the old database there were a lot of frauds. So this disruption may sometimes find out new frauds, but most of the time it may also disrupt the current practices, create confusion in the organization, leading to more opportunities. Secondly, if you are a fraud examiner and if you are in an organization, if you spot let us say a violation which appears to be deliberate, because when you talk to the DPO, he says, sir, I know that there is something, it's not perfect, but we cannot do anything more than this, something like that. I, as a person who is having some kind of mind on fraud detection, I will say that why is this person not trying to be compliant and taking the risk of exposing his company to a particular fine? Probably that is an indication that he is hiding something. Okay, so it can be an indication of that nature. The other part which I would like you to remember is sometimes certain privacy violations under PDPA may not have any direct loss impact on the organization, but it could be a loss impact on the society. And as long as the Data Protection Authority doesn't know, it will remain as such. So many organizations would like to hide certain data breaches or potential data breaches under the carpet. But sooner or later, it may surface, and at that time, the corporate which you are examining could suffer a loss. So whether you have got a duty to bring it to the notice of the management is something you can always look at. Apart from this, as Sharat was mentioning, if during the process of your examination, if you are taking certain data into your custody, because it's part of your fraud investigation, then remember that you are also liable for personal data protection as a data fiduciary. Your laptop becomes the source of a potential data risk. In fact, a lot of fines under HIPAA and other data protection acts have all been linked to loss of laptops, sometimes of the chartered accountants, lawyers associated with the company, because we import this data into our laptop and we will be analyzing it in good faith. But suppose I go to a mall and lose my laptop, the company is asked to bear the loss. So people who collect sensitive personal data into their custody should be aware that they become joint controllers in Gdpr parlance, or joint fiduciaries, data fiduciaries under the Indian context. And as a fiduciary, you are able to have the compliance measures as mentioned in this act and in its entirety. Not that it is only a company which has to do it. As a fraud examiner, collecting this into your custody and even having access in a corporate environment, you are going to be called a joint data fiduciary. Now, if you look at the impact of this at a glance, this is a legal mandate. Non-compliance could lead to a huge fine. It involves technical implementations of processes involved in data being collected, modified, stored, transmitted, and even deleted. It extends to that entire life cycle of the personal data. Of course, any new law brings in a lot more new employment opportunities because companies need hand-holding by experts. Now, I've been talking about penalties. The reason why we focus on penalties is that, like GDPR, this act talks of penalties in terms of the turnover of the company. There are certain offenses for which, it's not offense, it is contravention, okay, because it is a civil wrong. Now, the penalty could be 2% of the global turnover of the company. In certain cases, it can be 4% of the global turnover of the company. Then there is something which we have to, some norms which we have to follow on what is a global turnover. There could be possibility that your local turnover may be clubbed with the turnover of your subsidiary somewhere else, and the actual penalty will be running into a percentage of the global turnover. This is apart from the 5 crores for a limit for one category, 15 crores for another category. For governments, the limit is only 5 crores. Okay, so therefore, there is a sort of an unprecedented possibility of fines arising on an organization. Remember, every government department is also a data fiduciary. So they are also liable for the Data Protection Act management, which is a tough thing because within the government today, there is not much of an awareness of this data protection. I feel private sector companies are better placed because they know about data protection. They have been talking about GDPR for last several years. So for them to take PDPA compliance is much easier. But for a government departmental head, it is something new. Okay, so there is a need for a lot of awareness creation amongst the government departments, and particularly the secretaries, joint secretaries, and heads of departments. I feel we should have a separate training for them to make them realize that there is a need for some special action. In addition to the civil penalties, there is, of course, one particular offense which has been mentioned, which is called re-identification of a de-identified personal information. You know that in personal information, we call something as a personal information because it has got some identity parameters about an individual associated with the data set. Now, if you remove that identity parameters, it will become a de-identified information set. Sometimes we call it as pseudonymized set. If we remove the data identity particulars and completely destroy it forensically in a manner in which it will never be recovered, we call that as anonymized data. Anonymized data, of course, is not within the Personal Data Protection Act, but it all depends on how good is the anonymization. If the anonymization is less than 100%, it will be only called pseudonymized data or de-identified data, not really anonymized data. So there is one criminal offense with carrying 3 years imprisonment for re-identification of a de-identified information. And even if that is being done by a government official, the government official is liable for such a liability. Of course, with the permission of a superior, some procedural requirements should be there, but that is still there. So the people who are having access to personal data of citizens, public, and also large organizations which have got personal data of employees, they need to be careful that PDPA substantially changes their way of governing their departments. So briefly looking at the applicability, all types of organization, government, commercial, non-commercial organizations, they will be liable under PDPA. They will be liable to the extent they are processing what is called personal data. They will not be liable or for processing anonymized data or non-personal data. The corporate data will be non-personal data. and it will be coming into play if these organizations are either collecting, disclosing, sharing, or processing this personal data within the geography of India by using any equipment which is located somewhere in India. Okay, and for companies and any other entities which are registered under some law in India, which is the registration under the Companies Act. Basically, PDPA says wherever is your activity, whatever you are doing, it will come under PDPA. Okay, that is for those organizations which are constituted under Indian law. Within that, there is some exemption which is given. I will come to that a little later. Now, there are also entities which are actually constituted outside India. Okay, they may not even be present in India, so they are not doing any collection here. But sitting outside India, they may be doing some business related to selling of goods and services to Indian citizens or residents in India. So the end activity is going to happen here. Or sometimes they may sit there and do some processing of what we call as profiling the Indian behavior. So they will be liable under this act even if they are entities not registered in India, not present in India. Therefore, there is an extraterritorial application of this. Now, with this background, if we just look at what this PDPB 2019 talks about, there are different chapters. One of the chapters will talk about definitions and applicability. There are chapters on exemptions and exemptions in totality and exemption from one aspect of the compliance called obtaining consent. Then there are obligations to be followed by an organization, which includes the government in terms of compliance, non-performance of which will result in a fine. The Act also talks about certain rights guaranteed to the persons whose data is being processed. That is called data principles rights. There is separate coverage on how to handle children's data. There are restrictions on transfer of personal data out of India. Then there is chapter on the Data Protection Authority, adjudication, appellate tribunal, and so on. Then the penalties and offences. This is just a bird's eye view of the Personal Data Protection Bill. Now, looking at the compliance dimensions, one of the compliance dimensions we can look at from the focusing the requirements of the DPA. Organizations will require to be registered in certain cases. We call them as significant data fiduciaries. Organizations will have to develop what is called a privacy by design policy, which will have to be filed with the DPA. Like we file prospectus in the case of mobilizing funds. See, the concept which has been used in India is unique. See, just as a company which is raising money from public for investors want to declare its intention through a prospectus, a company which desires to process personal data has to give a document called privacy by design policy and make it public, so that the public who are contributing data, which we are saying data is valuable, etc., knows how this company is going to make use of my personal data. This thought process was not there in GDPR, but this is becoming a trend now, because the Dubai law presently, which was passed in last July 1st, has adopted a similar process. Similarly, the principle of calling the data subject as a data principal and calling the data controller as a data fiduciary, anticipating that this person will have to have trusteeship role in managing the data, is also very novel in India. It has been now being proposed to be adopted in US in the federal privacy law. So Indian law, even before it is becoming a law, is becoming a trend setter in the global market. There are a few more such things which we will see if time permits, I will try to talk about that. So there are restrictions on transfer, which the DPA will have to be satisfied with in terms of compliance. There is, in the case of minors, an age verification process, and whenever a data breach happens, sending the notification to DPA. These are the compliance measures addressed towards DPA. As regards the data principal, that is the person from whom the data is collected, one of the compliance requirements is to get an informed consent. A consent is like a contract. Informed consent means that we have to give a notice to the person, like you make an offer in a contract and get his consent. The offer and acceptance becomes part of the informed consent. It is like a contract. Over and above this, there is a fiduciary responsibility to the data fiduciary. Then internally, compliance requires some audits to be done internally. And this act has also said that when you do an audit, just don't say that it is I am satisfied or something like that. You have to give a score called data trust score. It is like your CRISIL rating or any other rating. That is, the auditor will have to not only make an assessment of how good is the data privacy practice of a company, but should reduce it to a number. So just a wishy-washy statement like most of the audit reports in financial terms provide is not acceptable. There is going to be a score to be given. So to that extent, there is a measurability of the compliance which is there in India. I'm not going into the details of what is called a privacy by design policy. Essentially, I would like to say that this privacy by design policy is a very comprehensive documentation of the organizational measures, technical measures, business practices, the way technology is architectured, the way policies are built, all driven to the requirement of meeting the objective of this particular act. The objective of this act is through data protection, how to protect the privacy of an organization. All that should be implemented by design, that is by default in the architecture of the particular business. Now, as far as the rights are concerned, one of the rights is any data principal can ask a company, are you processing my information? If so, what are you doing? Give me some details. That is called confirmation and access. Then if there is any errors in that, not updated, I have got a right to get it corrected. Then comes the more important thing. I have got a right to say that I have given this information for a certain purpose. Now that purpose is over, then why are you retaining it? Please erase it. So data erasure is a right of the data principal. Then he can also withdraw the consent once given. Then there is something called data portability. If a person says that please transfer whatever data I had given back to me or to some other person, when this data portability request comes, what is to be ported back is not only data which the data principal had given, like my name, address, etc., but also if you had conducted, say company had conducted a sort of a profile building, that profile also will have to be returned. So suppose there is a credit rating agency which has taken the information from me and then given me a rating, then I am entitled to get back that information also in data portability. There is a concept called right to forget, which has been introduced by EU in the Gdpr. Basically what it means is that a data subject, or here data principal, has got a right to tell a data processor, fiduciary, or a data controller that from tomorrow onwards, you should not have any information identifiable to me. Please delete all of them permanently and in a manner that it cannot be recovered. That is called right to forget. And as fraud examiners, you should be concerned about this right to forget. Fortunately, India has not blindly followed GDPR. Here they have said that right to forget will be exercisable only with the consent of an adjudicator. So it is not possible for a person, a terrorist, to simply send a notice to an organization and say, please delete all my data. Because that requirement may come sometime later on during investigations. A fraudster will be very happy to clear off all his data with an organization as a right. So Indian law does not permit automatic, you can say, deletion of data permanently, and there is an intervention of the adjudication process. Now that is the rights. Now generally the obligations of data fiduciaries otherwise is, whenever they process the personal data, they should do it for a lawful purpose, and it should be processed only for the particular purpose for which they seek the consent of the data principal, giving him the information through notice that I want this information for this particular purpose, I will keep it only for this particular period, I will delete it afterwards. Giving all that information, collect the information, otherwise don't collect the information. So that notice requirement, collect only what is required for the purpose, that is called collection limitation, then maintain the accuracy of the data over a period of time, don't keep data which is inaccurate, that is called quality of data, then retention, restriction only for a particular period. These are all part of the obligations, and the data fiduciary is accountable to prove that he has followed all these things when a DPA, Data Protection Authority, finally wants something to be done. This consent is the most important instrument of obligation, and the burden of proof that a consent has been obtained lies with the data fiduciary. It has to be a free consent, informed consent, specific to the purpose. It should be capable of being withdrawn. In case of sensitive personal information, it has to be explicit, not a general consent, and there should be no conditions attached to this. These are some of the things which the PDPA highlights. And in case, if a data subject wants to withdraw the consent without reason, the law says that the organization can charge him for certain fee. Okay, so that like this award WAPC, if somebody says consent WAPC, then that consent WAPC people will be charged a price. I feel this is a very important inclusion in our act, as otherwise in the Indian conditions, people will go to Aadhaar and say, please return all my consent. So that is not today easy in our law. Apart from the consent, which is almost mandatory in most of the cases, there are a few instances where consent can be excused. One is by the state when it wants to collect some information or use some information for the benefit of the citizens, like issuing of licenses, etc., or if any other law requires it or a court requires it, or in the case of medical emergency, and of course in case of disasters. In terms of employment situation, again, processing without consent is permitted in certain cases, but only for non-sensitive information, not for sensitive information like biometric and others. Like if you want to do for attendance verification, provision of service benefits, termination, recruitment, okay. In all such cases, performance assessment, there may be possibility of processing for which consent is not mandatory. Okay. If this was not there, there would have been issues. There have been issues in Gdpr where heavy fines have been implemented on organizations because a disgruntled employee becomes a whistleblower and says something is not happening in my country, in my company properly. Along with these things, there is something called legitimate interest. Processing is possible without consent. Prevention of fraud is one such reasons. Information security is another reason for which consent is not required. Then, of course, public available data, credit rating purpose, if there is a proven public interest. There are some exceptional cases where the data subject knows that there is no expectation of a consent, including search engine operations. So these are some of the exemptions which have been provided. I am highlighting these exemptions to say that this act has taken into account the needs of the industry and brought in flexibility required for that purpose. I already told you about these general exemptions which the government has, particularly under Article 19(2). Then for investigations, courts, personal, domestic purpose, journalistic purpose, small entities, manual processing. As far as foreign citizens processing is concerned, PDPA has provided that by notification, an Indian organization which is processing foreigners' data under a contract with a data vendor, they can seek exemption from PDPA so that we are not going to interfere in the BPO activity of that organization. Additionally, there is a sandbox provision which says that if any new company wants to test out some new processes where there is a privacy risk, they can seek to create a sandbox under the guidance of the Data Protection Authority and process it within that without the constraints of the Personal Data Protection Act. As far as small entities are concerned, which I told you can be defined by way of turnover, purpose, or number of data sets handled, there can be exemptions on applicability, requirement of notice to be given, quality maintenance, retention norms, then giving some documents to the data principal, then right of portability, right to be forgotten, and the compliance measures. There are exemptions, but as I told you, it is applicable only for manual processing. Now, in terms of fraud areas, potential fraud areas, I feel right to erasure and right to forget are the most important aspects which your kind of people to be worried about. Disgruntled DPO is a big risk. Disgruntled employees are a risk. Changes in technology sometimes provide a challenge and create fraud opportunities. Then there is a possibility of impersonation. Somebody else through phishing asks for some information. That kind of aspect. Then quality disputes. All these are some of the issues which you have to look at. I've added here this domain ownership of privacy because you know that both the current system, the owner of a particular domain who registers his domain with a, let us say, a registrar is using an opportunity not to be known through the who is contract, revelation. So that is one reason why many of the phishing and other things are happening, because we can't test and find out whether the particular domain is a genuine domain or not. Same way, and they try to justify it from privacy reasons. Second, this thing is in emails. So when you get an email in Gmail, you don't get access to the originating IP address today because Gmail says that I will not reveal it because it is the privacy of the sender. Now, where is the privacy of the receiver or the security of the receiver? If I want to know the IP address of the sender, then is it not my right? So this sort of a thing is still needs to be attended to. This is called, actually, I call it as a shared personal information, and probably this non-personal data regulation will take that into account. Now, as I was mentioning earlier, PDPA is different from GDPR. Compliance to GDPR or compliance to something called ISO 27701 is not sufficient. The government of India made a mistake earlier when saying that 43 capital A compliance is deemed to be there if there is an ISO 27001 audit certificate. I was vehemently opposed to that thought process. I hope that today the government of India does not make the same mistake and say, if you are ISO 27701 compliant, then I will consider you as PDPA compliant. If they make such a thing, it will be a gross mistake, because 27701 is geared towards GDPR, not towards PDPA. This is the reason I've listed here a number of changes, which I have also explained in the earlier slides. PDPA is different from GDPR. Compliance to GDPR is not sufficient. Similarly, 27701 is also not sufficient. It is for this reason that I have been trying to drive generation of a separate information security framework. I call it as Personal Data Protection Standard of India, and this will go directly towards PDPA compliance. This is one of the Atmanirbhar kind of an approach. We want India not to be dependent on ISO 27001 or anything else. We want PDPSI to be adopted with whatever changes are required to adopt to the best principles of ISO 27001. So this is in general what I wanted to share with you. For more information, you can look at my book called Personal Data Protection Act of India. You can aspire to be a certified data protection professional. You can look for all this information on fdppa.in. Now, I am open to your questions, though we have already come to the end of 1 hour. Okay. Yeah.
Sir, there are certain questions posted by the participants.
Yeah. I will first go through that
Chat box.
and
Yes,
try to see what can be.
Please, sir. Okay.
Okay, if anything cannot be answered, I'm still available on email or something. I will answer it subsequently. Okay. Now, the Mani Padmanabhan last question is, why should data be anonymized as a rule? The data relating to a person should be protected. Only if it has been used in an authorized manner should I anonymize that abused data. Is that correct? So here what we are saying is, I am not saying that you have to anonymize. See, if it is not anonymized, then it becomes an identifiable personal data and it has to be protected. But if it is anonymized in such a manner that it is irreversible, then there is no point in having any control on that under the Personal Data Protection Act, because it is no longer personal data.
Got it. Yeah.
Anonymized data may come to my hand after anonymization, in which case I am just picking up this data as a commodity and I am doing whatever I want with it, for which this new Non-Personal Data Governance Act may bring in some norms. That is different. Now, if I am already having a personal data, then I have completed its usage for me. Then if I anonymize it, that is one way by which I can perhaps disclose the anonymized data without affecting the privacy of the person who was the underlying data subject. So that provision is available. Now this new Non-Personal Data Protection Act has suggested that anonymization also should be subject to consent, which was not the original consideration. I think that is a reasonably good suggestion. There is nothing wrong. So in fact, under PDPSI, we have already adopted that as a norm. So our consent form will also have a provision that in case the company wants to anonymize and disclose it, I either give a consent or I don't give a consent. So that will be part of the consent. Okay.
Got it, sir. Yeah.
How CDPP different from ISACA? CDPSE. See, CDPSE is something which you can buy off the shelf if you have got certain years of experience. Okay. It's an experience-based certification. CDPP is based on what you learn out of our training and the examination which you pass as an online examination. It's possible that you may not learn everything which we teach, but we ensure that certification from FDPPI is only given on the basis of some incremental knowledge. Without knowledge, certification should not be available for buying off the shelf. So we don't believe that. And of course, CDPSE, you may have to spend some lakh of rupees, whereas CDPP, you spend only thousands. Okay. Why should that? Okay, then how RTI Act is going to be dealt with? Data Protection Act. See, RTI protects the right of one individual, okay, for information. See, if you are doing some fraud, and if I am asking some questions, is it not my right to know that you are doing a fraud? Now, you cannot say, I have got a privacy, I will not reveal you. Then there is a clash of two rights. One right of privacy, another right to information, right to free expression, and so on. So, RTI will coexist with data protection. So, whenever such a disclosure request is there, the organization has to make an assessment that if I disclose this information, am I causing any harm to ABC? And based on what we call as a harm audit, he will decide whether he should overrule the privacy right and give the information away. Anonymization is same as masking of the data? No, masking of the data is pseudonymization. It is reversible. Anonymization is irreversible. Okay, we'll go back to earlier questions. What are non-companies that are liable? It could be partnership firms, proprietary concerns, even an individual doing business for commercial purpose, government departments, charity organization, trusts, NGOs, everybody is covered under this particular act. So only exemptions are for domestic purpose if you are processing it, or a small business which is processing it manually. They are the only exemptions. Everybody else will come under the particular legislation. Okay. Of course, the DPA will exercise his discretion how to put a fine. They will not put, say, a 5 crore fine on an individual. That is left to their discretion. Okay. Since the data that is violated is personal data, who initiates action? Data Protection Authority is a new authority which will be set up. It is a body of 1 plus 6 persons, the chairperson and 6 members. It will be like a tri kind of a thing. It is a board which will be perhaps setting up its office somewhere in India, having its branches. It's a full-time job, and people who come in here are experts in law, they will be experts in technology, they will be experts in data science, they will be experts in big data, they will be experts in information and cyber crimes. Maybe a fraud examiner also should be part of this. So 1 plus 6 persons are going to be selected after this act comes into being within first 3 months. So that is an opportunity for people in the legal area can look at being an adjudicator who will be having an office attached to the Data Protection Authority. So these are all the authorities which will be coming, and the Data Protection Authority will also have access to external experts if they want. That we have to see how they use. Is it consequence-oriented, meaning when an individual or group raises a complaint? No, there is going to be a DPA, and within the DPA there will be an adjudication authority. So they will be always available permanently, and the DPA will also be monitoring the activities. So it is a proactive regulation, not like when the complaint comes kind of a thing. That is what Mani Padmanabhan has asked. Why non-sensitivity is covered? Is that not an overkill? Actually, Mr. Mani, this is a controversy which has been raised. Non-personal data is not being covered under PDPA. The only statement which has been made is government reserves the right to make any other law for non-personal data. That's all they have said. Now that is under that provision that this new data, non-personal data governance act may come in future. It does not regulate the non-personal data. It only says that passing this Personal Data Protection Act does not constitute a bar on government passing any future legislations on non-personal data. That's all. That is not covered here. Therefore, I have the right to do anything with that. That is what has been reiterated under Section 91 of this particular act. People have not fully understood that. Okay. Fine. Any other question? I will come down later.
There are certain questions at towards the end of the chart, sir.
Yeah, I will come down again. Okay. Now, while auditing foreign entities, do you think knowledge of GDPR, PDPA is sufficient, or any other laws? See, GDPR applies to the information coming from EU region. Okay. If information is coming from Singapore, GDPR is not sufficient. You have to know about Singapore law. If the information is coming from DIFC Dubai, you should know Dubai law. If the information is coming from US and if it is a health information, you should know HIPAA. If it is coming from California consumer information, you should know CCPA. If it is coming from New York, you should know New York law. So, depending upon the country of origin of the data, different laws may be applicable. GDPR is not a universal law. GDPR is actually EU is trying to make the law for the world. This is a new data colonization effort which EU is trying to do. Recently, they attacked US and said that whatever arrangement we had on US Privacy Shield will no longer be applicable because the EU court says, I am not happy with your US constitution. See, in what way the court of one country can say constitution of USA is wrong? But that is what they have said, and they said that because of that, I will not consider US as a country to which personal data from EU can be transferred freely. Okay, so that is called the rejection of the US privacy. shield. So GDPR is different. It is applicable to the countries which are within the EU region. Okay. Rest of the countries have their own regions, their own laws. There are supposed to be presently more than 80 such laws. So such laws will be applicable. So if you are an auditor and you are I'm talking of not a fraud audit, we are talking of an auditor for data protection of a company, and that company does business, let us say in Canada, you should know what is Canadian law. So GDPR will not be sufficient. So like that, you will have to look at different laws, and that is why global laws awareness is required for a comprehensive data protection professionals. There are various MOUs being entered between regulators such as SEBI, income tax, GST. When the data protection legislation comes, the DPA will be responsible for protection of personal data. So the sectoral regulators and the DPA have to work together harmoniously to ensure that personal data is still protected in a way that the privacy is protected. So this is something which the DPA has to work out with RBI, for example, with SEBI, IRDA, TRA, with all of them. But in terms of personal data, DPA will be the apex authority, and if it disagrees, sectoral regulators will have to fall in line. As a chartered accountant, what are the other skills for auditing? Remember, PDPA gives an exclusive opportunity for auditors because every significant data fiduciary is expected to have a mandatory data audit once in a year. Like you are doing financial audit, there will be a mandatory annual data audit that is applicable to companies which will be classified as significant data fiduciaries. So there is a great opportunity. But data audit is different from financial audit. By data audit, what we mean is how does the organization follow all the compliance requirements of PDPA? That is what is to be assessed. How they take consent, how they give notice, how they secure, do they use encryption, how do they do access control of personal data, and so on. Okay, if you make an assessment of all that, then you can also think of reducing it to a particular credit rating number that is called DTS, Data Trust Score. So that is something which is new, and chartered accountants will have to separately learn data audit. It is not financial audit. Okay, it is not even information security audit, systems audit. For a certified data protection professional, what other courses will assist? Nagaraju. Okay. Certified data protection professional should know the law of data protection. We feel that he should know about Indian data protection law as well as global data protection law, because most of the Indian companies have a mixed bag of personal data. He should know something about technology. He should know something about this data audit. And a data auditor, we feel, should also know about the behavioral skills which are exclusive for dealing in this kind of a situation. In fact, that is why our certified data protection includes 5 modules with all these multiple facets. Nowhere else in the world that concept has been used. Okay. Now CDPSE will also be into examination. Yes, possible. Now you register with $500, and for examination you pay another $700. People who are rich enough to do that, they can do that. Okay. But right now they are issuing CDPSE without any examination. Okay. Then what could be the sensitive data definition? We have to wait for the act to come because DPA will confirm what is sensitive. But basically the health information, financial information, biometric, genetic data, they can all become sensitive personal data in this context. Okay. So I think I have tried to quickly go through the questions unless anything more is there.
Yeah, one more, Naavi is up. One more thing. Mr. Tinkupadi asked, what are the difference between GDPR and PDPA? Of course, you have touched upon some points during the session. Yeah. So, can we list any other differences?
Yeah, I am now showing the slide. Are you seeing the slide?
Yes, yes.
Yes, sir. Yes.
One is.
No, I was asking. Sorry, sir. I was asking. I know you have listed out, but maybe 1 or 2, which is very important because GDPR also is this. The PDPA is also mostly what I understand has been taken some part of it is being taken from GDPR also, like 80% has been taken from GDPR. So maybe what is the most critical or a vital difference? If you can throw some light on that, that would be good, sir.
Let us focus on the first point. Okay.
Okay, sir. Yeah.
Here, a data controller is a data fiduciary. Okay. So what does it mean? In the data controller scenario under GDPR, you take a consent. Okay. Consent is like a contract. Data controller is appointing you. So if you are very intelligent in drafting your consent, you can get consent for anything you want. Okay. Whether it is beneficial to him or not, you say it is there in the consent. Okay.
Right.
So it becomes binding on the data subject. In India, what this says is, you take the consent. Here also consent is there. It has to be informed. You have to give a notice containing some 14, 15 points. Fine.
Right.
But you are a data fiduciary. You are like a trustee. If you are a trustee, you have to take decisions in with a duty to care the data principle. It is like an investment manager for a minor. Okay. You have to know what is good for that particular person. So that is one of the important differences. It changes the entire outlook. Consent is there. It is necessary but not sufficient condition. Okay. You have to actually think in terms of the harm caused to a data principle by any of your processing and take decisions on his behalf. That is the fundamental difference which makes a complete change. Then there is classification called significant data fiduciary registration. Then this privacy by design. See, in GDPR, it is your internal thing. Privacy by design should be implemented. Okay, you should have.
Right, absolutely.
Here, what you are adopting, you have to reduce it into a policy document and file that policy document with the DPA. DPA has got the right to make a public disclosure.
Right. I agree. This is one of the significant difference. Right.
It is a significant difference because there is a commitment of the management to that. Okay. Yeah. And if there is a difference between what you are actually doing, as I find out in an audit, and what you have already filed, if you have not modified it, that becomes a point. Okay. Then there is something called a consent manager. Okay. Who is a consent manager? In India, we take privacy, you give a consent, there are language restrictions, people don't understand privacy, so there is a need for somebody to assist the data principles. That has been done through the provision of a consent manager. There is a sandbox, as I told you, and the DPO, some benefits have been, the BPO, some benefits have been given. So there are a few differences. They are critical. That's what I'm saying.
Absolutely, sir. Absolutely. Thank you. Thanks very much for explaining this.
Okay. I could see huge demand for data protection consultancy firms. Yes. Of course, DPO has to be an employee, but you can always use the, in GDPR, DPO can be an external consultant. Okay. Whereas in India, he has to be an employee, so there is accountability within the organization. You have to designate somebody as a DPO. But you can always take the assistance of an external consultant to help the DPO. That is the best model under which you can work because it's a very complicated issue. And for under PDPSI, we recommend that you use something called a distributed model of responsibility. I will not go into the details now, but it's a onerous responsibility for the DPO. If I am the CEO, I would like to give him all the resources, but also give the assistance of an external consultant. Otherwise, I myself would feel that I am burdening my employee with a responsibility which is not easy to manage. Okay. Then, anything else I have left out?
I think you have covered everything, Naavi sir.
Yeah.
I don't find any other question unanswered.
Okay.
So I think we can close the session, sir.
Okay.
Okay. So
That's fine. Thank you, friends.
and 1 minute. Now.
Yeah.
So for the participants, if anybody need CPA certificates, I will post a Google form. Please respond in that. So we will prepare the certificates and email to you. And I'm grateful to you once again, Mr. Naavi sir. And I request our Vice President, Mr. Chandrasekhar Sharma, to give his concluding remarks. Mr. Sharma ji. Sharma garu? I think. Okay, he is not available, sir. So
Okay.
anyhow, sir, thank you, Naavi sir, for accepting our request instantaneously and giving us a lot of information, because some of us are not aware of these personal data protection laws. We hear only about GDPR and PDP bill in India, but not much about what they contain. So you have given us so much exposure to them. Thank you so much. And we look forward to have more sessions or workshops from you. And I also thank all the participants for sparing their time and participating in it. So thank you, sir.
Any
Thank you
other
so much.
questions you have, you please send it to me by email. I will answer. Don't worry.
Definitely, sir. And one more request: is it possible to share the PPT, sir? Some of the members are asking me a question.
I will actually give you a copy to the recording itself. Don't worry.
Please, please,
Okay.
please, sir.
Yeah.
So thank you so much, sir.
Okay.
Thank you.
Thank
Thank
So is the
you, Naavi sir. Thank you very much. It's a very insightful thing
Thank you.
and very useful to us also.
Yeah.
Sir, Naavi sir, it's a great pleasure for all of us
Yes.
that you covered each and every aspect of the data protection.
Yes.
And you have given me a nice transformation and differing perspectives it covered. Then you told about beware, be reliant, be compliant, be self-service, self-reliant, be vigilant. Excellently you dealt, sir.
Thank you.
And you told the importance of 43A and how it can be transformed. And that is again excellent. And how you have covered the body corporates to other corporates, how it can be done.
That is very, very interesting and contemporary
Excellent,
relevant.
sir. We all thank you very much for your excellent session. And
Valuable time.
we'll be more and more will be waiting for such sessions in future, which will help the fraud examiners. They will definitely develop their skills during their investigations. Thanks a lot, sir. Naavi, sir.
Yeah.
And I thank all the participants because who have come and they're all eagerly they waited. They've got a lot of again questions to you, and it's a great pleasure for all of us from the board itself. We thank everybody.